Are you looking to add your spouse to a deed in New Jersey? Perhaps this is part of an overall estate plan. You were recently married and it's time to reflect in the marital residence, the ownership that's happening on the ground. Or maybe you need both spouses to help have authority for decision-making when one spouse is not available. My name is Earl White, and our law firm is one of the premier real estate firms in New Jersey, and we help couples all the time make these type of deed transfers. This video is going to cover can you and how to add a spouse to title. What does it mean to hold on a deed ownership as husband and wife or civil union partners? What are the legal considerations that one needs to think through when adding or removing a spouse from title? And also your frequently asked questions when you are deciding to add or remove a spouse from title. First, can you add your spouse to title? And what does it mean to join the title as husband and wife? In New Jersey, you can add your spouse to title. You do not need approval of a lender. You do not need approval of the county or the state. You can prepare the conveyance documents and transfer ownership to your spouse or add your spouse to your deed to reflect husband and wife. Now, or civil union partners. Now, what does that mean when you update the deed to reflect it as husband and wife? There are 4 defining features of husband and wife on a deed, which is also referred to as tenants by entirety. So tenants by entirety have 4 features. You have unity and indivisibility, survivorship, creditor rights, and termination and conversion upon divorce. So for unity and indivisibility, when 2 spouses join title together, all decisions for selling, refinancing have to be made jointly. One spouse cannot make a decision to impact the title of the deed which they both own with any liens or other legal encumbrances without permission of the other. So that's unity and indivisibility of ownership. Then we have survivorship. Survivorship means, it's quite simple, that if one spouse passes away, the property automatically, without the need to go through probate proceedings, the property automatically transfers to the other spouse, as opposed to the surviving spouse having to go through probate to get authority over the property. Then we have creditor rights. The reason creditor rights are unique when it's husband and wife is because the creditors cannot fully foreclose on the property if it's only one person. So say you have a husband and wife, one of the couple has a judgment against them. Courts have ruled, the court judgment in which a judge says you owe someone money. The courts have ruled in New Jersey that when that judgment can only be enforced against the spouse that have the judgment against them, and they can't foreclose on the whole property. So it's very important. One spouse has a legal problem, that problem could attach to the assets, and it could attach to the property for that portion, but they cannot force it to sell, force a foreclosure sale if that's held by both spouses. And lastly, termination upon divorce. A unique aspect of tenants by the entirety, husband and wife, is that if the individuals do happen to get divorced, then the parties will automatically have a tenants in common, which means that if one were to pass away, basically survivorship goes away. If one passes away, then their share will go to next of kin and not automatically to the other upon divorce. Okay, so you are allowed to do a deed transfer to your spouse without any special approvals needed, and we went over the legal considerations for doing so and what it means. Now, the process to do so has several stages. First, you have to make the decision to that this is in your best interest and consider the legal considerations. Next, retain a real estate attorney. Although individuals may prepare deeds for themselves, the act of preparing and recording a deed is the act of law. So only an attorney or yourself can do it. And obviously an attorney is going to have experience, do it faster, particularly if they have done many similar deed transfers in the past. And this is usually a relatively affordable process, not going to cost thousands of dollars for a basic deed transfer. Once you retain your attorney, then the documents have to be prepared. The primary documents are the deed itself, which should specify in the grantee, the person receiving ownership, both spouses' names and husband and wife, or sibling union partners, if that's the case. There's also a get rep form and also an affidavit of consideration form. So those terms need to be prepared, then they must be signed. The deed itself and the affidavit of consideration needs to be notarized either by a New Jersey public notary or an attorney. The get rep form we mentioned, that form does not have to be notarized. It can just be signed by the current owner alone. Now the documents have been prepared and signed, they must be recorded with the county. So how does that work? In modern times, when this video is being created in 2026, the deed must be submitted to the county. And the way that will work is either through e-recording, in which case we upload it online, it automatically goes to the county, and then they process it on their end. You can also do it old school, mail the paper or drop off the paper at the county. Though that seems like it doesn't save much money on the e-recording costs, and you have your paper deed stuck in the mail, and then you have to keep going back and forth whenever you have to do a revision or an update or something that the county asks you to do to the deed. Once this deed gets recorded, then you want to update your insurance companies. You want to check the city records. It'll probably lag a little bit because the documents are recorded at the county level. So you want to make sure the city records get updated to reflect the county, 30 to 60 days, update your insurance. The next question that you have to ask yourself before adding a spouse or removing a spouse from the deed is whether it's in your best interest to do this. Obviously, you'd want to have a strong relationship with your spouse. If you're thinking that it might not go well or you're having any other marital problems, then sure, it would not make sense at that point to add your spouse to the deed. But let's just say everything is amenable and anticipated to be that way for the indefinite future. Now, it may make sense in this case, but you still want to ask the question, is the person being added to the title likely to have any legal problems? If they are going to have any legal problems, such as court judgments against them, lawsuits involving the property, creditors, these type of things, although the creditor in Tenants by entirety can't foreclose on the property, they still can make a claim to your spouse's interest in the property, which could be millions of dollars. This depends on whatever the judgment is. So you want to make sure when you're adding someone to the title by doing a basic title search that there are no judgments, just to verify there's not any even fraudulent issues, and that it's unlikely that adding the person to the spouse would expose the property to any heightened legal liability. You also want to examine any tax consequences of adding your spouse to the title. Now, they may get better or worse. I'm not an accountant or tax attorney, so I couldn't answer those questions, but it's important to run that by whoever your tax advisor is, that this change of title is not going to negatively impact your tax circumstances. Also, if you already have an estate plan drafted in place for what's supposed to happen when one of you were to become deceased on the title, run it by your estate planning attorney too, to make sure this is consistent with the intent of the will, trust, whatever that estate plan you have developed is. Let's go through some of the frequently asked questions that my clients ask when we're beginning the process of adding a spouse or removing a spouse to the title. First, can I add my spouse to the deed after a real estate closing? This becomes an important question because you've had, prior to the real estate closing, you've had contracts drafted with only one spouse's name. You've signed mortgage documents with only one spouse's name. A title company has officially recorded a deed, officially for a separate deed with only one spouse title. So can you even do this? Certain people may ask. And yes, of course, we already talked about in the beginning of the video that you can do the deed transfer and the closing process. Although you probably want to wait 60, 90 days to let things settle, the closing process does not prohibit you from doing the deed transfer. Now, generally speaking, there could be a mortgage. If there's a mortgage on the property, there is federal law that states that the lender cannot exercise what's called a due on sale clause if the transfer is to a spouse. Other transfers, other transfers are extremely limited. You can't just transfer to a friend, a family member, some family members. You can't just transfer to a friend, a company. Otherwise, the lender could call the loan due. Spouses, there's a federal exception, so they cannot do that. Next common question. Can I add my spouse to the deed after marriage? Yes, absolutely. Marriage is one of the primary reasons, like the change in the marital status is perhaps one of the most common reasons that the clients will contact us to update the deed because they want the deed to reflect the reality that now there's two people living at the marital residence, and the deed should be added to both spouses because now everybody has decision-making authority. If it's only one person on title and something happens to them, challenging their capacity, and you didn't have a power of attorney, you would be very thankful at that point that both spouses are on the deed, because otherwise you would have to go to guardianship to actually have decision-making authority. Another question, can I add my spouse to a deed but not the mortgage? Yes, absolutely. We mentioned the federal law that prohibits the lender from foreclosing on the property or calling the loan immediately due when there's a transfer to a spouse. So should I use a quitclaim deed? The promise on the deed, so quitclaim, bargain and sale deed, this doesn't necessarily have a significant impact for a transfer to a spouse. But presumably, if the parties are on the same page and are open with each other, then both are knowledgeable of any liens on the property. The quitclaim deed, the idea is that I'm not going to make any promises to you. You're just going to get whatever title I have, quality of ownership I have, regardless of the liens on the property. So it doesn't need to be, you could add it in there, but it doesn't need to be part of a marital deed. In fact, I would argue that it's probably more appropriate to have a traditional bargain and sale deed with a covenant against grantors acts. That means that one person that's transferring title is saying, we have not put any liens. What's going on? I think it is appropriate to have a bargain and sale with covenant against grantors act. This way one spouse is formally telling the other, I haven't done anything underhanded. You can also remove this paragraph altogether if it's not a requirement for recording a deed, but you don't need the quitclaim deed. You can use different formats of the deed or not include quitclaim or covenants against grantors acts language and still get the deed recorded for purposes of updating the title to reflect a marriage. Last kind of question is, how much does it cost to add a spouse to a deed? And so there's two elements of this. One is the legal fee, and two is the recording fee, like the amount of costs to accomplish the deed recording. For legal fees, most attorneys will do this for a flat fee. Typically, if it's a really straightforward situation, it would be under $1,000 to just add a spouse to a title. $600 to $1,000, just depending on the attorney and perhaps some of the complexities that are relating to this specific transaction. Recording costs are typically going to be $130 to $150 to the county, depending how many pages that you're recording. And then also, either typically if you're using an attorney, we will either overnight the documents to the county, or if it's like my firm, we will do e-recording for the deed, which has an approximately $50 cost, which can change a little bit depending on the county and the day, but approximately $50. So about $200 in cost. So legal fee, you're looking at probably less than $1,000. And for recording costs, between county costs and overnighting or e-recording, around $200 as an estimate.